Good afternoon, everyone. My name is Ben Barros. I'm Dean of the College of Law. I'm delighted to welcome you to today's Stranahan National Issues Forum lecture. This series began in 1990, supported by an endowment from the Stranahan family. The forum is a joint program between the University of Toledo College of Law and the college's Federalist Society, with the purpose of addressing issues of national importance through the lens of the American legal system. Over 40 of the nation's leading legal academics, economists, historians, political scientists, judges, and public policy professionals have participated in the Stranahan National Issues Forum. To introduce today's speaker, it's my pleasure to turn to Lee J. Strang, the John W. Stapler Professor of Law and Values at the College of Law. Professor Strang came to the College of Law in 2008 after teaching at 2 other law schools. He's an accomplished scholar and teacher. Among his many other duties, he is the faculty advisor to the College of Law's Federalist Society chapter and coordinator of this lecture series. Professor Strang.
Thank you so much, Dean Barros. Today's Stranahan lecture, like the lecture series more generally, provides a necessary contribution, a necessary perspective to our university's debate and discussion on important national issues. It's therefore my distinct pleasure to introduce this fall's Stranahan lecturer, Professor Adrian Vermeule. Professor Vermeule, the Ralph S. Tyler Professor of Constitutional Law at Harvard Law School, is a graduate of Harvard College and Harvard Law School. After law school, Professor Vermeule clerked for Judge David Santel on the U.S. Court of Appeals for the District of Columbia Circuit and for Justice Antonin Scalia on the U.S. Supreme Court. After teaching at the University of Chicago, Professor Vermeule has taught at Harvard Law School since 2006. A member of the American Academy of Arts and Sciences and the Administrative Conference of the United States, Professor Vermeule is a prolific scholar, authoring or co-authoring 11 books on administrative law, institutional design, legal theory, including, most recently, the topic of his lecture today, Common Good Constitutionalism. In his Stranahan lecture today, Professor Vermeule will argue that the classic legal tradition is very much with us, and that it helps to make sense of our founders' jurisprudential commitments and our current public law. He will argue that the classical legal tradition both can and should be explicitly recovered in American public law and legal theory. Professor Vermeule will speak for approximately 40 minutes, leaving some time for questions and comments. Please join me in welcoming Professor Vermeule.
Excuse me, I'm technologically extremely challenged, so I have to get my stuff together up here. Thank you all for having me, and thanks to Lee and the Dean, especially for hosting. If everyone can hear me okay. I'll talk today about common good constitutionalism, and Lee stepped on my initial lines a bit, just kidding, but common good constitutionalism is a translation or adaptation of the classical legal tradition to our current world, or so it aims to be. I hope you'll take the talk as in part a reflection on and an effort to reconnect American constitutional law with the broad mainstream of the Western legal tradition, the so-called jus commune, including the Anglo-American common law as a kind of local variant. Of course, that river, that broad mainstream, has many tributaries and complicated branches. Still, there is a larger continuity that connects the tradition of the jus commune to the 1780 Constitution of my home state of Massachusetts, which is often cited as a model for the federal Constitution. That Constitution of Massachusetts specified that all shall be governed by certain laws for the common good, and went on to claim even more ambitiously that government is instituted for the common good, for the protection, safety, prosperity, and happiness of the people. And we will see that that verbal formulation in the 1780 Massachusetts Constitution is one that would have been perfectly familiar to the 13th century lawyers of northern Italy. It's a time-honored classical formulation. And then it proceeds, of course, to the U.S. Constitution's own preamble, which specifies that one of the master aims of the Constitution is to promote the general welfare. All these are drawing on even more ancient sources, going right back to the origins of European law. Sources such as the etymologies of Isidore of Seville in the 7th century, which says that laws properly so called are formulated for no private benefit, but for the common well-being of the citizens. and ultimately to the opening book of the Digest of Justinian, the great classical legal compilation / code, that grounds the validity of the public law of Rome in the public interest, the utilitatem publicum. So any account of constitutionalism that ignores the central place of the common good in Western legal theory is, for that very reason, an inadequate account. So my book aims to just participate in this central tradition, and it's an alternative to two main forms of legalism that dominate the American legal scene today, which I call progressive legalism and originalism. The former is very prominent in the academy. The latter view is less prominent in the academy, more prominent in the American judiciary. Although interestingly, originalism is marginal or indeed non-existent in the practice of most European, Latin American, and other judicial systems. It simply doesn't exist. It's largely an American phenomenon. Originalism comes in a bewildering cacophony of versions, but most simply understood in the version typically cited by originalist judges, it claims that the Constitution must be read according to its original public meaning as of the time of enactment. Now, in my view, despite their superficial enmity, progressivism and originalism are mirror images of each other. They are both aspects or variants of a kind of common duopoly. They flow from and share the same basic positivist premises about law. Both, for example, deny the intrinsic binding force of the natural law, either in the case of progressives, because they often claim to think that natural law doesn't exist, that there is no law other than human-made law. Although, interestingly, when talking about intrinsic human rights, that view seems to fall by the wayside. Or in the case of originalists, because they believe that natural law is binding at most only insofar as it is incorporated in positive law, a form of so-called inclusive positivism. Against both camps, I argue that the classical tradition should be explicitly remembered. This is really a work of memory, and recovered and adapted as the matrix within which American judges read our Constitution, our statutes, and our administrative law. I claim that this is, for centuries after the founding, right through sometime around World War II or after, this is the American legal tradition, and we've somewhat forgotten that. The project thus has both a general and a particular part, and this is explicit in the classical legal approach. It speaks both to general principles of the nature of law and to the specific instantiation or embodiment of those principles in the American constitutional order. Now, those two are detachable in the sense that one can subscribe to the methodological framework without subscribing to my particular interpretations of American public law, and I'm happy to talk about that more later if you like. So I want to come back to this theme of memory. Putting aside the work of a few legal historians and other specialists, our legal theory, as opposed to our legal practice, has all but lost the memory of its own origins and formative influences in the classical legal tradition. The jus commune was heavily influential in England in a somewhat variant local form. Both the English common law stream and the continental civilian stream influenced Americans right from the beginning, throughout the 19th century and well into the 20th. The barest acquaintance with any substantial body of law from the founding era and through the 19th century and beyond shows, in my view, the truth of something that the legal historian Jonathan Gignac said, and I'm going to quote. He says, "Originalists' understanding of constitutional writtenness is anachronistic. It's a species of modern constitutional thinking that they unwittingly and uncritically impose on the 18th century. Founding-era constitutionalists, by and large, were not positivists. They tended to think that much of law was just out there, like the principles of mathematics or natural philosophy, awaiting discovery through reason and observation. And as I say, the founders in this regard were just following the English common law tradition of their time, which profoundly influenced their understanding of the legal ontology underlying the general and public understandings of legal terms. I mean, if you look at Blackstone and the way that Blackstone's 4 books are arranged, they're arranged according to a rather peculiar scheme: the rights of persons, the rights of things, and then actions, or public and private wrongs. That scheme seems odd, especially I think today to law students. Where does it come from? It comes from the Institutes of Gaius, the sort of standard intro textbook of Roman law written in the 2nd century AD. So that's just an illustration of the continuity of the tradition that was influencing the framers. Of course, Blackstone was one of their major legal textbooks. So this classical legal tradition was explicit in legal practice well into the 20th century. The precise timing of the breakdown is immaterial for my purposes, but it's clear that by the 1960s and 1970s, a radical shift had occurred. But if you go back and look at old cases, which I strongly encourage, you'll see it everywhere. So I was talking with the dean last night about American property and nuisance law in the 19th century, which is importantly ordered around some crucial maxims of the Roman law, stemming directly from the Digest of Justinian. And this is the kind of thing we've just forgotten. More broadly, what we've forgotten is one of the cornerstones of the American legal tradition itself. The positive law based on the will of the civil lawmaker, while worthy of great respect in its sphere, is contained within a larger objective order of background legal principles and can only be interpreted in accordance with those principles. Now, I'm not proposing a simple return to the classical legal tradition and its particular legal rules. Even were that feasible, which it is not, one would simply risk recreating the conditions that caused the present to come into being. But what I do suggest is that the theoretical insights and jurisprudential principles of the tradition, its fundamental legal ontology, that is, its claims about what kinds of law there are, can be recovered, adapted, and translated into our world so as to yield a better interpretation of the past and present of our own constitutional order. Those insights are not so remote as to preclude recovery. In fact, one of my running claims in the book, and it'll be one of my running claims in this talk, is that our law is, as it stands and as it is practiced routinely today, far more classical than our legal theory acknowledges or even comprehends. That is, key elements of the classical view of law already remain vital within our law, although they're not recognized as such by our theorists. So what does the classical tradition hold? The centerpiece of the classical view of law is that law should be seen as a reasoned ordering to the common good. It's neither all reason nor all fiat. It's a sophisticated combination of reason and will. Law is an act of purposive and reasoned governance that promotes the good of law's subjects as members of a flourishing political community, and ultimately as members of the community of peoples and nations. All officials have a duty and corresponding authority to promote the common good, albeit in a manner consistent with the requirements of their particular roles. So this classical conception in our American legal tradition tries to unite well-ordered reason with public authority. Classical law treats enacted texts as what it calls determinations. This is the process of giving content to a general principle drawn from a higher source of law, making it concrete in application to particular local circumstances or problems. So the need for determination arises when principles of legal justice are general and thus don't specifically dictate particular legal rules, or when those principles seem to conflict and must be harmonized or balanced and have to be given determinate content. There are typically multiple ways to determine these background principles of legal justice while remaining within the boundaries of the basic charge to promote the common good. Aquinas gives an analogy of an architect who's given a general commission to build a hospital for a city. And this architect possesses a kind of structured discretion. That is, the purpose or end of the commission shapes and constrains the architect's choices, while not fully determining them. A good hospital can take a number of forms, although there are some forms it can't take. So, for example, general principles of legal justice might say that at some point, peace and order require that potential defendants should have repose from the risk of being sued. But of course, there's a whole myriad of further determinations that go into the specification of particular statutes of limitations or tolling rules for all sorts of different legal acts. So determinations are thus products of the reasoned prudential judgment of public authorities who give specific content to the law. Now, the classical law continues, the determined law of a particular jurisdiction, which it calls the jus civile, should be read in light of the background principles of legal justice on which the determination is based and should be harmonized with those principles. So it tries to read positive law in light of the jus gentium, the law of nations or peoples, and the jus naturale, the natural law. Put differently, the classical tradition distinguishes, as many European languages still do, between two senses of law, which it calls, a little bit of Latin here, lex and jus, I-U-S. In Spanish, these are ley and derecho. In French, these are loi and droit, and so on. English, to its misfortune, has no stable version of these distinctions and instead uses law and rights in confusing ways. Lex is the enacted positive law, such as a statute. Jus is the overall body of law generally, including and subsuming lex, but transcending it and containing general principles of jurisprudence and legal justice. That's the sense in which I might say I teach administrative law, which includes laws in the sense of statutes, but goes far beyond it to include all sorts of broader principles. So lex is a determination of use, but doesn't exhaust its content, and the classical lawyer says should be interpreted to harmonize with it. That's the fundamental legal ontology. Now let me say something about what exactly is the common good, and I'm going to proceed from a high level of abstraction down to a more specific level of abstraction. At the highest level of abstraction, the common good is, for the purposes of the civil constitutional lawyer, the flourishing of a well-ordered political community as a community. So if you wanted a box, a mental box, to put this approach in, you could call it a kind of communitarian approach to constitutional law. The common good is unitary and indivisible. It's shared without being diminished. That is, it's not like a pie where if I cut off a piece and give it to you, then the pie is shrinking. It's more like, this is a very humble analogy, it's more like the victory of a sports team, which is the victory of all of us severally, but also of us jointly as a team. It's not an aggregation of individual utilities. It represents the highest felicity or happiness of the whole political community, which is also the highest good of the individuals comprising that community. Let me pause on that last proposition for a second. No man is an island, and the goods of individual and family life, although extremely important, can't be enjoyed in a decaying and chaotic polity. And that's true even if we can afford to live in a gated community and immunize ourselves to some degree. I think we've discovered in recent years that no amount of self-immunization is really sufficient. Aquinas puts it in a very striking passage. He says, the individual good is impossible without the common good of the family, state, or kingdom. And I continue to quote, he says, hence Valerius Maximus says of the ancient Romans that they would rather be poor in a rich empire than rich in a poor empire. They'd rather be poor in a rich empire than rich in a poor empire. I think that's an extremely striking thought that is not particularly well captured by a lot of our individualist economic theory. To give all this more specific content, then, the tradition proceeds at successive levels of specificity. And it begins with the precepts of legal justice in the classical law. Ulpian has a famous trio. He says, Juris praeceptus sunt haec honeste vivere, alterum non laedere, sum quicque tribuere. That means to live honorably, to harm no other person, and to give each one what is due to them in justice. This trio of principles, as I said, was routinely cited in American case law throughout the 19th century. And then the tradition expands or develops these principles at ever more concrete levels. It articulates the central goods at which constitutionalism should aim. These goods include, in a famous trinity, peace, justice, and abundance, pax justitia and copia, or peace, justice, and good government, or peace, order, and good government. All these feed into both American constitutional law and sub-constitutional law, both at federal and state levels. They're the foundation for the so-called police power, but you also see them in constitutional instruments at various levels, as I illustrated at the beginning. One has to do a little bit of work in the book to translate or adapt these principles as I extrapolate them to include various forms of health, safety, and economic security. One of the running themes in the book is that I am largely a fan of the administrative state and its efforts to promote modern versions of peace, justice, and abundance, and I can talk about that in the Q&A as well. Okay. The common good, I want to be clear on this view, is it's a type of justification for public action. It doesn't by itself prescribe any particular legal institutions or rules, leaving aside cases of intrinsic evils like theft or without some other justification or intentional killing of the innocent and so on. Generally speaking, the common good has to be applied to a set of particular circumstances by means of the faculty of prudential judgment. This is a virtue for public authorities. It's the virtue classically known as regnative prudence. It's the prudential judgment oriented towards legal justice of someone charged with the care of public matters. And this is by no means unstructured discretion. It's given shape by an account of the ends for which discretion must be used. The obligation of the public authority is to act according to law, meaning that the public authority must act through rational ordinances oriented to the common good. That's the very simple outline of the positive view. Now let me briskly dispel some myths and misconceptions, and then I'll say some words about some of the competitors to the classical view. First, the common good is not preferences or what I like or whatever the governing authority imposes at whim. One sometimes hears a claim that I take to be tendentious, that the only alternative to positive textual rules is a kind of unstructured discretion that embodies subjective preferences or policy arguments. The Western legal tradition, however, has always supposed that positive law is not fully determinate, that other binding sources of law and background principles exist with potentially ascertainable and objective content. Thus, in hard cases, or especially in hard cases, where positive lex is ambiguous, vague, general, internally conflicted, seemingly conflicts with enduring background commitments of the law generally, or is otherwise underdetermined, those other sources of law can and should be drawn upon to determine legal meaning. A legal ontology that consists only of texts on the one hand and policy preferences on the other, it's impoverished and it's inconsistent with the American legal tradition from the founding onwards, and it's inconsistent with the broader sweep of Western legal theory. So common good constitutionalism isn't legal positivism. It doesn't identify all law with rules laid down as a matter of social fact by those authorized to do so by conventions. It allows that the truth of legal propositions sometimes depends on the truth of propositions of political morality, specifically the subset bearing on legal justice, and holds that those principles are themselves part of law, binding of their own force. But I want to dispel here another occasionally heard misunderstanding. The classical law builds into its own theory great respect for the positive law. As I said, positive law is a legitimate specification by the public authority of general principles of legal justice. And this implies that the judges or other officials who interpret law at the point of application are presumptively bound to follow a kind of respect for the text, whether understood according to its ordinary meaning or according to the intentions of the lawmakers. That's a subsidiary question. But the crucial point here is this is not the positivist form of textualism that simply equates law with positive texts. So Justice Gorsuch recently wrote for the court that only the written word is the law. And that is a proposition from the court's arguably leading originalist or most self-conscious originalist that the classical law simply rejects. Rather, on the classical view, a kind of respect for text is justified by reference to the good of the community. And positive enacted texts are thus always read against the backdrop and in order to accord with the broader legal background of general and traditional legal principles, the law of nations, the natural law, and so on. So the classical law incorporates positive law without being positivist. Okay, another misconception, the common good is not the good of the collective as opposed to that of individuals. The idea is not to override individual interests as a kind of sacrifice for the collective good. That is a misconception that arises from a particular theory of rights which the classical approach doesn't share. Rather, the classical approach says that because the common good of a flourishing political community is itself the highest good for individuals as such, rights very much exist. I want to underscore this, but they're justified in a different way. They're not justified in the essentially individualist and autonomy-based fashion familiar today. Instead, rights are recognized insofar as doing so contributes to the common good. The common good is built into rights from the ground up. Put another way, rights are objective corollaries of duties. Duties of legal justice, which is the constant aim of giving every person their due. Use, this Latin term for the body of law generally in legal justice, use is what is due to every person, and in that sense includes rights. The classical tradition does not, or not primarily, see the point of natural law in particular as the overriding of positive civil law. That's an important strand of the natural law tradition. We see it in Dr. Martin Luther King Jr.'s letter from Birmingham jail, where he directly cites and quotes Thomas Aquinas on this point. But that is historically not at all the major focus of the classical tradition. Rather, the major focus of the classical tradition is interpretive harmonization, drawing upon these higher principles of law to help us understand what the positive law means, always, but especially when the positive lex is ambiguous, vague, or internally conflicted. The classical tradition doesn't require or presuppose judicial supremacy, doesn't license judges in particular to rule as they see fit for the common good, all things considered. Division of roles and allocation of jurisdiction is central to the classical law. The Digest of Justinian puts it right in the first book. It says, the magistrate is said to render legal right use even when the magistrate makes a wrongful decree. The reference, of course, being in this case not to what the magistrate has done, but to what it is right for the magistrate to do. So that's an interestingly subtle distinction. Role morality and division of functions are built into the classical law. What the classical law does suppose is that the positive law is always to be read in accordance with higher law, and that the positive law can turn out to be underdeterminate. And at that point, other binding sources of law enter the picture. Okay, let me now turn to the competitors to the classical tradition, the two views that I said dominate our public legal theory today. I want to be clear that I say here public legal theory, not our legal practice, and I'll return to that point in a bit. Today, as I said, both progressives and originalists either deny the existence of the natural law altogether or deny its relevance to law except in inclusive positivist terms as a background belief potentially incorporated into the positive law laid down by the framers and ratifiers. This is not, of course, the classical approach to higher sources of law. For example, to say that one follows the natural law only if and to the extent that it is embodied in the positive law is a kind of ersatz form of respect for the natural law. One would then be obeying it only insofar as it happens to be picked up by a positive command, but not because it has binding force as natural law in its own right. It's intrinsic to the natural law that it should be followed for its own binding force, not merely because some incumbent ruler commanded that it be followed. It's not followed at all if it's not followed as natural law. And this is something John Finnis has recently emphasized, that the natural law is ipso jure, it's binding law itself, and he says judicially applicable as part of the jus gentium, as part of the law of nations and peoples. My key methodological point, and in part also a polemical point, is just that originalism and progressivism both stand on the same side of a gulf that separates them from the classical legal tradition. Both camps attempt in different ways to reduce all law to human will, to the will and choice of officials. For them, all law is in this sense lex. But because use is lost to view at the level of theory does not mean that it has actually been purged from American law. Far from it. The classical vision of law has merely been driven underground. Judges and others unavoidably and unmistakably work with some account or other of the common good and of law's ordering to that good. It turns out when we look at our legal practice that all law legislates some morality or other. Let me make this point especially with respect to originalism. Since its modern inception in the 1960s and 1970s, originalism has never been able to free itself from the implicit normative assumptions and judgments needed to attribute rationality to legal texts, to determine the level of generality at which the meaning of constitutional text should be read, and otherwise to make sense of their terms when texts are ambiguous or underdetermined. Originalism is in that sense an illusion. It's not what actually happens in practice. And I think the decisions of our Supreme Court and lower federal courts give ample testimony to that daily. It proves over and over again impossible to avoid interpretation that rests on controversial normative judgments of legal justice at the point of application. Originalist decisions of the Supreme Court turn out to be richly interpretive and normative. They're shot through with claims about political morality taken as part of the law. The only questions are whether we are transparent about that and which account of the good our law will promote, pursue, and endorse. I don't know if this is a digression, but it's one I feel strongly about. Because no law can operate without some implicit or explicit vision of the good to which law is ordered, a legal theory that doesn't understand or denies that it's ordered to some vision of the good or other is lacking a kind of natural immunity. And it is extremely liable to be infected by actors with a particular vision of the good that they kind of interpolate into that legal theory. In my view, what I've called the illusory positivism of originalism has therefore largely been hollowed out and taken over by a substantively libertarian constitutional vision. So we see this in all sorts of areas. Originalist libertarians purport to be horrified by purposive rule for the common good, but they defend the role of common law judges in purposively fashioning and protecting property rights. They evince hostility to the administrative state and condemn any departures from the putative original understanding, except in areas such as free speech, non-delegation, and regulatory takings of property rights, in which the law propounded by conservative judges is either expressly or arguably non-originalist. And I'm happy to flesh that out with respect to those particular areas if you like. On social matters, originalist judges have written opinions such as the decision in Bostock versus Clayton County, and I think this is a methodologically extremely illuminating opinion. This is a decision that declared sexual orientation and gender identity protected from discrimination under the civil rights laws. My point here about Bostock is not whether we substantively agree or disagree with this. It's about a methodological point that it raises. I think it's a crucial one. Bostock nicely illustrates a basic claim of originalism's critics, that the choice between or among levels of generality, between specific expected applications and more general meaning of phrases like discrimination on the basis of sex, cannot be made without appealing to normative principles of political morality and legal justice. There's no way to do that. It's not a question of doing originalism right. It's built into the structure of the problem. So Justice Gorsuch's opinion for the court faced the following issue. The specific expected applications as of the time of enactment, 1964, would certainly not have included gender orientation and, sexual orientation and gender identity. So he's faced with this kind of strange originalism that would have been unanimously voted down by the legislators who enacted the statute and by the public that elected the legislators who enacted the statute. So what Justice Gorsuch says is, no, we have to read this discrimination on the basis of sex at a higher level of generality, not according to specific expected applications. And he's quite aware that he needs to give some justification for reading it at that higher level of generality, not at the level of specific expected applications. And I want to read you the main justification he gave. He says that to read the statute according to its specific expected applications would, quote, tilt the scales of justice in favor of the strong or popular and neglect the promise that all persons are entitled to the benefit of the law's terms. Now, we can have a separate conversation whether those arguments are right or wrong, but my methodological point is that they are certainly arguments of political morality and legal justice. There's no way to avoid that dilemma by appealing to originalist premises itself. It would be trivially circular to appeal to the original understanding to decide at what level of generality the original understanding should be read. One has no choice but to look elsewhere to principles of legal justice, to use, and have a debate about what the content of use is. Okay, so originalists have recently evolved an attempt at a solution. I've discussed this with Lee, who's made a recent contribution at a panel that I thought was great and illuminating, and I want to mention that to his credit. And Lee brought up the topic of so-called closure rules. So responding to a question whether judges should be able to apply maxims of natural laws, canons of construction, to find the meaning of a positive constitutional text where texts remain underdeterminate after attempts to ascertain its original meaning, Lee quite rightly noted that there was no conventional originalist position to address this question. I think that's a significant observation in itself. But Lee then also quite rightly proceeded to note that originalists have worked hard to identify additional conceptual resources to create so-called closure rules for cases of underdeterminacy. So some examples that he gave are seeking out originally understood legal rules of interpretation and historical evidence, or where that fails, so-called Thayerian deference, that is, deferring to political authorities so long as their views are reasonable. See, my view, however, is that these closure rules just replicate the problem they're intended to address. That is, they're subject to this exact same problems as the first-order rules for which they attempt to provide a kind of tourniquet of determinacy. The very fact that there are multiple possibilities for closure rules underscores this point. One faces inevitably a choice between possible closure rules. It's not just written in the nature of things or inherent in the nature of legal language or something like that the interpreter should choose one approach or the other. Here are some possibilities. Frank Easterbrook, Judge Easterbrook, once suggested that originalists faced with underdeterminacy should simply put the statute down. I think that means rule against the plaintiff, but I'm not exactly sure. Another possibility is, as other originalists have suggested, rely on party presentation of socio-historical facts. Another is the Thayerian approach I mentioned, and the list goes on and on. The point should be obvious, which is one faces at this second-order level, the meta level, the same problem that Justice Gorsuch faced at the first-order level, is you have to give some justification sounding in political morality for adopting one approach or the other. So, for example, let me turn to the thought that originalists might use original rules of interpretation and evidence as closure rules. The problem is, and I think we saw this quite dramatically in the recent gun control case, the Bruin case, rules of historical evidence rest on express or implied normative assumptions and arguments about things like the costs of decision-making, the costs of error, the institutional capacities of different legal actors, the collateral and systemic effects of admitting or not admitting certain categories of evidence, and a myriad of other topics. And these are more or less on the surface, although sometimes in the footnotes of the Bruin opinion. A legal scholar named H. Jefferson Powell put it this way in an article I really enjoy. He says, rather than avoiding the responsibility of choice, history requires of the originalist a whole new range of contestable decisions. There is no escape from normative argument about what our rules of historical evidence should be. Well, I need to wrap up soon. I just want to finish with a few thoughts on why there's been a revival of interest in the classical legal tradition in the United States. And in my experience, it's been especially pronounced among practicing lawyers and judges, law students, law clerks, and younger professionals. And I think there's a kind of reason for that. Some of the reasons are essentially negative, involving the faltering of the alternatives. Originalism has fractured in interesting ways, to some degree undone by its own success. At the academic level, there are now maybe a dozen increasingly sophisticated or perhaps recondite versions of originalism. They include original meaning originalism, expected applications originalism, original methods originalism, original law originalism, and I could pretty much go on all day. Amid this rather chaotic welter of versions of the theory, the claim of originalism's academic proponents to offer determinacy, as opposed to the supposed manipulability of any alternative, ring hollow. That is, any particular version of originalism may or may not be determinate, but one has to choose between the versions. At the judicial level, likewise, outside the academy, the fact that Justices Jackson and Kagan have openly and in some sense proudly described themselves as originalists also raises questions about the determinacy of the approach. But I think the impetus behind the revival of classical legal theory runs much deeper than this. It stems from the parlous state not of law and legal theory, but of the larger polity. So I want to suggest a kind of paradox that's rooted in the Aristotelian claim that we know through contraries. That is, we know about health by being sick, or we know about wealth by being poor, and so on. As a polity becomes increasingly disordered, increasingly remote from a naturally well-ordered regime promoting peace, justice, and abundance, the claims of the common good and indeed the natural law become more visible, more insistent, and less debatable. So it's easy to be sort of fashionably skeptical about the common good when your polity is more or less doing well and flourishing. Intellectuals can focus on edge cases and exceptions because the main tasks of civil governance are being taken care of in the central cases that matter. But suppose you live in a polity that is, in some sense, in decay, where disparities of wealth and inequalities of educational opportunity are pervasive, where fentanyl has become the leading cause of death for adults between 18 and 45. Pause and think about that for a second. 1 million Americans die in an epidemic. Judges are harassed in their homes over cases they're currently deciding. The list goes on and on. In circumstances like these, it becomes thinkable again that a flourishing polity is a real thing, a real goal of the law, and is itself really the highest good for individuals. That's something that's brought home to us in our experience. It's no accident, I think, that the last major revival of classical legal theory, and there was such a revival in recent memory, it occurred in the 1950s, just after the Second World War. Why did it occur then? Because the horrors of the Second World War brought home to people that there really is such a thing as a well-ordered public community. And, of course, the idea that positive law doesn't exhaust the binding sources of law was brought dramatically home to people at Nuremberg. So under those circumstances, I think the revival of classical legal theory was natural, and similar causes explain its revival today. Okay, thank you. I told Lee that we had a wonderful dinner last night and we're going to have a lunch today. If there are questions, I'd love to especially hear from people who didn't have a chance to be at either the dinner or the lunch. So,
yes, please.
Thank you. I appreciate that, your lecture. You described progressivism, originalism, and natural law. I was kind of picturing them as maybe three different pillars. Do they ever intersect? Is there an area where you think originalism could say, well, I do subscribe to natural law? Or do you think that they're mutually exclusive?
no, not mutually exclusive. So this is one of my running conversations with Lee and with other originalists. So there's a really positivist version of originalism like you see in Justice Gorsuch, and then there's, in my view, more sophisticated version of originalism that Lee puts out in a wonderful book in 2019, if I remember, that tries to ground originalism itself in the natural law. And there's a large domain of cases, call them the easy cases in the legal system, in which the classical approach and this kind of approach yield exactly the same result. I mean, they're yielding it on different justifications, but in operation, the judge or practicing lawyer is kind of doing the same thing. A lot of cases, you don't have to agonize about larger principles. It's, a straightforward regulation or something. So there is a lot of common ground. But there's always this possibility of not common ground breaking out into the open because of the difference in justifications between the approaches, and that comes to the fore in hard cases. So to the extent that, for example, the Bruin opinion understands itself as determining the meaning of the Second Amendment solely with reference to socio-historical facts, I think that's not what's going on, and it can't be what's going on. And this is putting aside, what we think about the merits of the decision reached. This is purely a point about how to interpret law. And it's cases like that that bring the difference to the surface. So too with the classical legal approach and progressivism. So my views in the book are far more consonant with the views of American legal academic progressives on a range of topics. So on environmental law, on the administrative state, and all sorts of topics like this, where I think that there are genuinely common goods, the environment being almost the paradigm of a genuinely common good, that law properly should make it its business to protect and preserve. So there's a lot of common ground there, but of course, again, the justification is often different. I mean, the most common thing I hear from self-described progressive legal academics is that law is frequently indeterminate, and that when it is, it's just a matter of politics. What view is imposed? And that's not a view that the classical law agrees with. The classical law view thinks that there really are objective principles of legal justice kind of that are mind independent. Now, we could be wrong about them, and we have to argue about them all the time, but it's not just an expression of will or something. So there's common ground on both sides, but always the possibility of difference breaking out because of the different structure of theory underlying the views.
We have time for one more question.
Yes, Professor, in light of the Dred Scott decision of Hudson versus Ferguson, where did the common good manifest itself?
Yeah, I mean, Dred Scott was totally wrong. And John Finnis, who I mentioned, the Oxford legal scholar who defends a version of this view, is wonderfully eloquent about this. He says that the mistake of Dred Scott is to try to pretend that the posited constitutional law is internally complete without reference to principles of human rights and principles of legal justice that could easily have been brought to bear on the decision of the case. One of my heroes in the book, speaking of Plessy versus Ferguson, is the first Justice Harlan. So you see how it goes. Look, I think that, and this will be my parting thought and maybe a Parthian shot, I think that the American Constitution is a spectacularly poor candidate for positivism. It's short, it's general, it's ambiguous and or vague in a lot of its provisions, and a lot of its provisions essentially use terms of art that are pointers to a developing classical/common law tradition. I think that positivism would be much more suited, although I would still reject it, for something like the Brazilian Constitution, which, if I recall correctly, is the world's longest and full of highly specific technical constitutional specifications. Our Constitution's not like that. It cries out to be interpreted in accordance with higher legal principles, and it should have been, obviously, in Dred Scott. Thank you.
And with that parting shot, please join me in thanking